All right, afternoon, everybody. Let me get chat situated over here on the side and we will get into it. Yesterday was my first final. We had property, or yesterday was Crim law. Today we're going to be studying property. Let me get this settled. Okay, there we go. All right. So yesterday we had Crim Law. I'll break down a bit of what that was like, how it went, and then after that we have property today. That's what we're mainly going to be reviewing, and other than that, just some news on some stuff that's been going on. But before I get into that, let me turn up my fan. It's getting hot in here. All right. So, and here I'll double check, make sure that that's working, and it is. Okay. All right. So yesterday was Crim Law, and that was probably going to be the most intense exam that I have this semester. It was closed book, no notes, no nothing, so I had to have everything memorized for it, and it was all multiple choice. So you either knew it or you didn't know it. There were 90 multiple choice questions. We had 3 hours to do it, and on average, it took people between like an hour and a half to 2 hours. So it was relatively short, pretty straightforward. But even still, there were a lot of questions that were a bit tougher. I'd say maybe about 65 to 70 were pretty straightforward and I felt confident on. The other 20 to 25 were a lot more thought provoking and you had to put a lot of time and effort into trying to answer them. But after talking to some of my classmates, I think that I ended up doing fairly well on that. And that I'm happy with that because I didn't have a chance to study the day before. I had some personal stuff, some family issues going on the day before the final, so I barely had a chance to study. So the only time that I really studied was the two live streams during the weekend before that. So maybe like 5, 6 hours. So I'm extremely happy with how I did, or how I think I did. I won't know for another like month or so. But before we get into studying for today, I have some very good news. Yesterday, as I was heading out the door to my final, I got a call from a law firm. I sent them an application almost a month ago, and they never got back to me, so I assumed that I was off their list. But they called me yesterday. They said that they are just starting to work through stuff now, and I told them I'm on my way to a final. I can't really talk now. We rescheduled for this morning, and I had what was supposed to be a 10-minute phone interview turned into like 25 minutes. And they're actually bringing me in tomorrow evening for an in-person interview, and I might have a summer job lined up. So I already have another like small job. I'm working as a TA slash research assistant for ASU, and that's all online and mainly going to be on evenings and weekends. So it's not going to be that much extra work for me to do something at an actual firm. But I'm happy that I might have something actually going on this summer. I don't know if it'll turn into anything, and it's just for a personal injury law firm and not a massive one at that, but it's something. They said starting salary is $16 an hour, and I'd be working between 20 and 24 hours a week. So between that and my TA position, I should be able to make ends meet for rent, and I'll still have plenty of time to work on this, and hopefully this summer I'll finally be able to get this channel monetized. I've been at this for quite a while, and we still don't have enough watch hours, which is part of the reason why I'm doing so many live streams, because you guys seem to enjoy these. Like, these are averaging like 9 watch hours during the course of a 3-hour stream, so like at least 3 of you are staying for the entire thing, and then people are watching them later. So it's really beneficial for the channel, and I appreciate you all sticking around for it. If anybody has any questions on how my Crim Law final went, or what things are looking like for that potential job, feel free to let me know. Oh, I just realized that they're having me come in for the interview at 4 p.m. and with the time difference, what time does the NFL draft start? Here, let's look that up real quick. Not that, let's go here. 2023 NFL draft. By the way, I really don't want to be studying right now. I'd rather be watching film. Oh, it's 5 p.m. our time here. Okay, so I'll be getting back just in time because they said 30 minutes to an hour for the interview, so I'll be back like probably as the second pick comes up. I don't know if any of you would be interested in seeing me live react to the draft, and maybe, I don't know, but I'm really looking forward to this. The Bills need a ton of help, and I'm actually going to make a video or a short on the draft as soon as I'm done with this stream. But before that, we have to actually study, and we have to actually go through the stream. I'm not sure how long I'll be on today, because I do need to prepare for that interview tomorrow, and I do want to relax, and I want to do some stuff to prep for the NFL draft, but I've barely prepared for my final that is on Friday, which is, nope, not this. Come on. I don't know why random shit keeps opening up. Oh, it's because I have, there we go. Oh my gosh. It's because some water got on my mouse pad here. I've barely prepared for property. Like, you guys saw me do my preparation the other day, and this is what we got. We got like 3.5 pages of an outline done, and we got through maybe like a quarter of the material, so there's still a lot to get through, and this final is Friday morning, so that's what we're going to go through today, and I'm hoping that I don't have any more issues with the random stuff opening. I think it was just I got a little bit of water from the condensation of this on my trackpad. I need to get a much better setup. Like, you guys probably hate how bad the camera quality is for all of these because I'm just using my laptop's webcam. So as soon as I have the disposable income, some of the first things I'm going to do are going to be get a better quality camera and get an actual PC instead of just going off of my laptop. But that's for the future, and for now, we have to study for property, because I've been putting it off the entire time that this stream's been live. Okay, so I have the outline from that other class open here. I'm going to use this as kind of a reference, but this was taught by a different professor, so it's not going to be everything that I need. But the main thing that I'm going to have are the PowerPoints, and I'm making my own outline here, and I'm going to rearrange that so that way they're next to each other. So let's do a quick review of what we went over on, I believe it was Friday was the last one that I did. And this is perfect because the first PowerPoint that we have to go over, it has a recap of everything, so, and it'll be nice to have a refresher before we get into some new material. Alright. So, on Friday we went over what property is and some of the justifications for it. So, property is oftentimes viewed as a bundle of rights in law. It's not just a physical thing that you have like most people would think it is. It's a bundle of rights and a bundle of duties that you have. So you have rights to everything that you own, the right to use it, the right to exclude other people from using it, the right to destroy it, and the right to transfer it or to give it to somebody else. But you also have certain duties, like you have the duty to maintain certain things, stuff like that, the duty to not cause a nuisance to your neighbors. So those are the those are the things that are within the bundle. Those are the rights that are in our typical conception of property's bundle of rights. And then there were a couple of justifications for why we want to have property and why we should allow people to own private property. And these are all right here. These also justify who gets the property, like first possession. Who gets to the property first? Sometimes we use that to decide who should have the property. Another theory is the labor theory. You're entitled to the first year labor if you work to build up your property and to make it as nice as possible. You're entitled to have it. Utilitarian theory, we just want to maximize happiness and utility within a given society. So allowing people to have private property will increase this. And I'm constantly talking about private property. This is just because that's most of what property law is about, is private property and individuals' rights to their own private property. There are some laws and a lot of research going into public property and stuff like that. We'll get into that further into this review session. And then the last two theories or justifications for property are the civic republican theory. This says that if you have a stake in property, you're more likely to vote and participate in a democracy, so that way you can maximize their use of it. So allowing people to have private property helps promote our democracy. And then the personhood theory. We all have personal attachments to the things that we own, and oftentimes a lot of what we think about ourselves is the things that we possess. So since the property that's around us, both real property and personal property, like rings, pieces of jewelry, books, they help us identify who we are, and we want to maximize that, so we should allow people to hold on to those things, and we should protect people's rights to those things. So those are justifications for property. After that, I already mentioned that property is a bundle of rights, and I mentioned each of these rights. There are certain rules with each of them. A lot of these will be referenced back to as we go further into the material for the class, but these are just the backgrounds of it. If you have questions on these, let me know. I'm not going to go over all of them now. You can pause the stream and read them, or also you can go back and listen to my explanation on the prior live stream. It was on Friday. But those are all of our rights and some of the stuff that's surrounding them. We have other laws relating to those rights, like nuisance is a limitation on your right to use your own property. You can use your own property basically however you want, so long as it doesn't constitute a nuisance to another person. These are all, whenever you see these like clovers, this is stuff that I copied and pasted directly from the PowerPoints, and these are the factors or elements that go into a certain law or charge or whatever. So in order to constitute nuisance, it needs to be intentional, non-trespassory, unreasonable, and substantially interfere with someone's use and enjoyment of their land. So those are the 5 elements of it, and they each have their own little definition next to it. Other than that, the main things that we covered were how you can acquire land. One of the basic ways is acquisition by discovery. This has a lot of weird nuance to it, such as conquest counts as discovery, and since land ownership and property rights are prescribed by law, even if you think that you owned property, if a new government comes in and they change the property rights, then they could take away your property. And the big example of this is Native Americans. They tried to transfer some of their land and sell it, in the Macintosh case, they tried to sell it, but the United States government said that they didn't have the right to sell it or to transfer it. So the transfer was invalid. And they said that because the English government discovered America they had the conquest over it, so therefore all of the land went to them, and they owned the land. They were allowing the Native Americans to use the land and retain some of the rights in the bundle of rights theory. Like, they could live there and use it, but they couldn't transfer it. Another way to obtain possession of something or to acquire land is adverse possession. And this is when you take land from someone else. There are very strict requirements on this, but this is basically a way for you to take title or take the right to land that you didn't outright pay for. And the main way that you do this is by using the land openly and in a manner that's kind of hostile to the actual rightful owner. Hostile doesn't mean that you're threatening them or anything. It just means that you're intending to exclude other people from it. And you need to do this for an extended period of time. There's actually a pretty fun case that's going on right now with this lady on TikTok who bought some property that butted up to a creek, and when she bought it, she didn't realize that everybody used part of her land for creek access because it was adjacent to a public park. So people had been using it for 30 years openly, but she wasn't from that area specifically, so she didn't know that that was going on. And now she blocked it off, didn't let people keep using it, and now the government there is trying to claim that parcel of land via adverse possession. I personally believe that the outcome of that case is that they're going to get an easement, which means that the public and the government can use that land, but they won't own title to it. Like, they'll have an easement to be allowed to walk across that land and use that access point, but they won't be the actual owners of it. But this is just a hilarious thing that's going on TikTok. This lady's absolutely batshit insane. I suggest that you look it up if you're interested in it. So, yeah, that is what we've covered up to this point. And what I was just talking about is adverse possession in relation to real property, i.e. land, houses, stuff like that. The first thing that is on the agenda for today is adverse possession of chattels. And chattels are not, they're property, but they're not real property. So they're things that you have that aren't land or houses. So rings, your car, your couch, all the books that you own. Those are all chattels or personal property. Depending on what jurisdiction you're in or what textbook you're reading, they'll call them different things, but they're the same thing. And you can apply adverse possession to personal property. Now, this is something that I'm not super familiar with. I actually missed this class, and they don't do recordings for my property class. They do them for like all my other classes. So I'm not super knowledgeable of this in particular, but we'll work through it together, and then we'll get back into stuff that I know quite a bit better. But let's just work our way through the PowerPoint, and then we will go from there. Like I mentioned, personal property are things other than land, airspace, or things that are physically attached to the land, such as your house. There are tangible things, which are chattels, and then there are intangible things. Copyright, patent, stock, things that you can't physically hold. The first case that we have on this is Reynolds versus Bagwell. We're just going to, instead of looking at all of these timelines because they can get confusing, we're just going to jump to what the rules are from them, especially since I didn't actually read these cases, so those timelines aren't going to be very beneficial. But let's see. The evidence reflects that the violin was purchased by an established dealer in musical instruments in the city of Norman and by him sold to defendant for use of his daughter in taking violin lessons, that it was kept in the sitting room of the home, carried back and forth and used by the daughter in taking lessons from several music teachers. There is no evidence of any intent to secrete the same from the view of anyone. Reynolds' case establishes the common law rule that once the elements of adverse possession are satisfied, the adverse possessor takes title. So, okay. Now that we have the rule, we can jump back to the timeline and kind of piece together what happened. So, in 1933, the violin was stolen from its original owner. Later on that year, it was purchased by an established dealer who later sold it to the defendant in this case. The defendant is the person who gave it to their daughter to use. And in 1935, the statute of limitations ran from the point in which it was stolen. In 1936 or 1937, the appearance of it changed drastically, which would make it unidentifiable, and it wouldn't end up being open possession if somebody took a look at it. And then in 1938, the plaintiff discovers that the defendant has the violin and they sue them. But since the statute of limitations started the second that it was stolen, this claim to repossess the violin cannot be satisfied. And replevin just means that you get the object back. That's a common phrase and a common term that you will see in property and in contracts. Replevin means that you get the object, that's opposed to monetary damages. It's just a type of claim. So, let's toss in our outline. And I'm actually making an outline for this class because I'm allowed to bring outlines into the finals, or into this final. Some of them I'm not allowed to, like Crim Law was closed book, closed everything. You just sat there with a Scantron and the questions, and that was all you were allowed to have. Here there's actual stuff that you can bring into the final with you. So let's go. Oh my gosh. You guys get to see how bad I am at typing again. Okay. Now let's get back to the PowerPoint. Okay, I remember this case being discussed, but again, I wasn't here for this day, so we'll figure it out. It might actually be better to look at the timeline first and then jump to the rules from it. So O'Keeffe, this is actually Georgia O'Keeffe, the painter. So in 1946, the paintings are stolen from a gallery. Then 6 years later, that's the statute of limitations in whatever jurisdiction this was in. That's when the statute of limitations would run, but that's a question that we're trying to figure out and answer. Is when does the statute start to run? Does it start to run when they're stolen, or when the original owner discovers that it has been stolen? So in 1972, so 20 years later, or 26 years later, O'Keeffe has the theft reported to the arts dealers. In 1975, she learns that the paintings are in a New York gallery, and a year later, she demands the return of the paintings and sues for replevin. Again, replevin just means that you're suing to get back the object. So, the questions for this are the elements of adverse possession satisfied? Is there actual possession? And this is, does the New York gallery actually possess them, or are they just displaying them, and the owner who has, or the person who like lent them to the gallery, are they the ones in actual possession? Is it continuous, adverse and hostile, blah blah blah? These are all the ones that we saw before, and yeah. Okay, so here are the rules that we get from it. So, to avoid harsh results from the mechanical application of the statute, the courts have developed a concept known as the discovery rule. The discovery rule provides that in an appropriate case, a cause of action will not accrue until the injured party discovers, or by exercise of reasonable diligence and intelligence should have discovered, facts which form the basis of a cause of action. We conclude that the discovery rule applies to an action for replevin of a painting. Cause of action accrued when she first knew or reasonably should have known through the exercise of due diligence of the cause of action, including the identity of the possessor of the paintings. So, and let's take a look at the UCC and what it gives us for this. UCC is just Uniform Commercial Code. This is basically the standard for any transaction of goods. Anybody that goes to law school, you will study this a ton when you're going through contract law. You'll have the restatement, which is any other type of contract, and the UCC, which is any contract or transaction for a physical good. The UCC tends to govern it. Certain states will have like different laws and rules in particular, but by and large, the UCC is the governing law on it. So, a purchaser of goods acquires all title which he has transferred, had or had power to transfer, except that a purchaser of a limited interest acquires rights only to the extent of the interest purchased. So, I know that's legalese and it's kind of hard to parse through, but when you buy something from somebody, you're buying the title or the rights to whatever rights they have. So say that somebody is selling you a car without a title. When you buy that car from them, you're buying whatever rights that they had. So you're buying the ability to use it until you get pulled over, or the person that actually possesses the title of the car comes forward to try and take it. By you buying it, it doesn't mean that you suddenly get a title when there wasn't one beforehand. You can only buy what the other person had. And then this little bit about purchaser of a limited interest, that's just there so that way if you only want to buy like, say you're purchasing a timeshare, say you only want to buy the rights to use this like X number of days per year, you're only acquiring the right to use the property X number of days per year. A person with a voidable title has power to transfer a good title to a good faith purchaser for value. When goods have been delivered under a transaction of purchase, the purchaser has such power even though the transfer was deceived as to the identity of the purchaser, or the delivery was in exchange for a check which is later dishonored. Okay. Let's try and break this down. Okay, so if you if you have a voidable title, then the purchaser is purchasing in good faith, they can obtain a good faith title, which is just a full title. So those are just the rules under the UCC. Let me jump back to our outline and just pop the discovery rule in. And I'll re-explain this in just a second. I don't know why this is bugging out a little bit, but let's go here. And then, oh God. I hate that it does it like this, where it just doesn't want to format correctly. It formats with the breaks that you saw on the PowerPoint, which, like, I don't know why it does that, but it does, but oh well. Okay, so discovery rule. A cause of action begins to accrue, so the statute of limitations starts to run for adverse possession when the actual owner knows or reasonably should have known that a cause of action was taking place. And that just means that when you realize that somebody's using your property, or you should have realized that somebody's using your property, or in the case of chattels, when you realize that property's been stolen and is in the possession of person X, or if you reasonably should have known that it's stolen and in the possession of that person, that's when the statute of limitations starts to run, and that's when you're able to start, like, pressing suit. So, even though the paintings were stolen in 1946, the statute of limitations doesn't start to run, so this 6-year statute of limitations doesn't start to run until the owner either knew or reasonably should have known that their paintings were stolen and were in possession of another individual. So I forget how this case actually turns out, but feasibly, if you don't realize, like, O'Keefe has the theft reported in 1972. That means that's when the statute of limitations is going to start to run, because that's when she realized that the paintings had been stolen. The defendant could make a claim that she should have known they were stolen beforehand, but the discovery rule just tells us when the statute of limitations starts to run. Okay, so that is basically all that we have on adverse possession to start with. Next, we're going to get into one of the most confusing and unfulfilling, I can't think of another way to say it, parts of property law, and that is the ownership of airspace rights and subsurface rights. So how much of the air above your property do you own, and how much of the land beneath your property do you own? And this varies drastically from jurisdiction to jurisdiction, but let's work through these. Again, I wasn't here the day that we went over this PowerPoint, so I just picked up on this as we went through, but we'll get through it together. Okay, so defining the vertical dimension, so defining, like, height in this situation. Traditional view, which is our common law approach, expresses in the, that's a shit ton of Latin that I'm not going to say. In theory, the surface owner's title extends upward to the heavens and downwards to the center of the earth. That's the traditional view. Like, if you buy a property, and typically you'll think, oh, I own the rights above my land, and I own it down to the earth, and you basically think that you own that, like, chunk from the center of the earth all the way up to the atmosphere. That's the traditional view. That's not how we actually apply it in law, though. In modern law, courts have increasingly modified this absolutist approach. Uh, there, there aren't precise upwards and downwards limits as to how far your property rights go, but most places nowadays do not say that you own property down to the center of the earth and all the way up to the heavens, like is the traditional view. They start to limit it. So the first case that we have on this is United States versus Cosby, and for those of you who are unaware, in law school, almost everything that you're going to learn isn't by reading actual law. You read cases, and you figure out what the law is by seeing how the judges apply the law, and that's what you learn. Like, you're required to learn the law by seeing it applied by judges. And this is what we call case law, and it's beneficial because all of the cases that you'll work on as a lawyer and they're decided later on are decided based on the standards set before them. There's this thing called stare decisis, which just says that if a case was decided a specific way in a jurisdiction beforehand, you apply the same law, the same rules, the same way to future cases. So with that being said, we cover a lot of cases. United States versus Cosby is about a dude who owns some property, and there's a plane that flies over his property. At least I'm pretty sure. Yeah, there's a plane that flies relatively low on his property, and they're trying to decide whether or not he owns that airspace, or it could be used by the government and air traffic control and everything. So, defense relies on Air Commerce Act of 1926. United States has complete and exclusive national sovereignty in the airspace over this country. They grant any citizen of the transit and air commerce through the navigable airspace of the United States. And navigable airspace is defined as airspace above the minimum safe altitudes of flight prescribed by the Civil Aeronautics Authority. This is all just a bunch of legal jargon. And this is what the United States is basically saying, though, is that we own the rights to all of the airspace in the United States, and we can fly at any altitude over anything that we want, so long as it's above the minimum safety threshold. And the question for this case comes down to, what is that minimum safety threshold? Is 67 feet above someone's house too low? Is that like below the minimum safety threshold? And that's what they try and figure out. So the Court of Claims, the first court that this went to, found that the U.S. had taken an navigation easement over the plaintiff's land. An easement just means that you're taking the right to use somebody's land, and navigation easement, they've taken the right to fly over somebody's land, valued at $2,000. And when you take something, when the government takes something, because of the, I forget which amendment it is, but the government isn't allowed to take from private individuals without just compensation. Because this will drive me crazy. Takings. Okay, so Fifth Amendment. That's what I thought. I was going to say Eighth, but that was what we use for proportionality in Crim law. So, Takings Clause of the Fifth Amendment to the United States, nor shall private property be taken for public use without just compensation. We'll cover this a lot more in the later stuff for property law, but this is saying that the government can't take your land without justly compensating you, so paying you. There are a lot of questions surrounding what's actually a taking, but that's the basics of it. They can't take your land unless they pay you for it. And that was kind of what happened here. The initial court found that the government had taken the plaintiff's land, so the farmer's land, even though it wasn't actually his land, they'd taken the right to use the airspace above his land, and the Supreme Court affirmed this decision, which means that they agreed with it and they upheld the lower court's decision. And their rationale was holding that flights over private land are not a taking unless they are so low and so frequent as to be a direct and immediate interference with the use and enjoyment of the land. And that language is very similar to what we have for nuisance law. Immediate interference with the enjoyment and use of the land. That's what we have for nuisance law. So flying over private property isn't a taking. So if a plane flies over your house, the government isn't taking from you. They haven't taken the easement to fly there unless they do it so often and so frequently that it interferes with their use and enjoyment of the land. And in such a case, a servitude has been imposed upon the land. The government has taken something and made it worse without compensating for it, so they would need to compensate for it, which is that $2,000. So the government can keep flying their plane over your property, even if it's so frequent and so low that it causes a disturbance, so long as they pay you for it. The government can take from you so long as they pay you for it. And like I said, we'll get more into takings later, but we're going to adjust our outline a little bit. I feel like I'm way behind because all of my classmates have had their outlines done for a while, and I'm making mine now. So we're covering airspace, rights, and subsurface. And a lot of this stuff is very interesting if you care about takings and how much of your property you actually own. So here is our Cosby case. And the rule that we get from that is, damn it, I hate that it does this. Okay. So, what we get from Cosby is this rule right here. Flights over private land are not taking unless they are so low and so frequent as to be a direct and immediate interference with the use and enjoyment of the land. In that case, a servitude has been imposed. It's a taking. The government needs to pay you for it. So if you're thinking about how to apply this in real life, if planes fly over your house once a week, that's probably not a taking, but if they fly over every single day, you might have a case. Let me just adjust that. Okay, there we go. Now back to the PowerPoint. Here's just some more rationale on why the court decided it this way. So, if the landowner is to have full enjoyment of the land, he must have exclusive control of the immediate reaches of the enveloping atmosphere. And this is just the court's reason why they upheld it. They gave us the rule that it's only taking if it's so low and so frequent that it causes that disturbance. But here's the rationale as to why it applied in this particular case. So, a landowner must have exclusive control over the immediate reaches of their enveloping atmosphere. So, the immediate reaches is the airspace right above their land. And that's the airspace above, like, structures that they use, trees and stuff like that. Otherwise, buildings could not be erected, trees could not be planted, and even fences could not be run. So, a justification for why we allow people to possess the air above their property is because if you didn't allow people to possess any of the space above their property at all, they wouldn't even be able to build their houses, because if you just owned the land and not anything above it, you wouldn't be able to build up from it. So you need to allow people to possess the space immediately around what they have. Okay, so the region immediately above that zone which the surface owner does not occupy physically, but which he uses in a manner akin to the space between buildings to provide light and air. So this is setting a limit to how high above it can go. And it's just what's immediately above what you're physically using. So what's immediately above the trees, what's immediately above your house or any other structure on your property that you're using in a similar way to like the space that you have between two separate buildings. That's something that you see oftentimes in cities and places where it's closely packed together. There are a lot of complaints that there's not enough space between buildings and they aren't getting enough light or air. We're applying that same logic above people's houses to see how far above somebody's property or how far above their inhabited zone that they physically occupy you can say that they own, and the standard is how high above they're using in a way that's similar to that space between buildings. Last couple of things relating to the decision of this case. So the super adjacent airspace at this low altitude, so close to the land that the continuous invasions of it affect the use of the surface of the land. Okay, so this is the exact rationale why they decided in this particular case. So the adjacent airspace directly to this land, they were so low that it was actually causing that interference with the use on the surface of the land. Okay. After that, we didn't really talk about Heinen's case or Heineman's case that much, or maybe they did during the day that wasn't there. Let's skim through this and see what we can get. Also, before that, let me see if I need to take anything from this. I should probably take this for the outline. I'll take 1 and 2 from the from this for the outline. Okay. There's 1. Let's take the next one as well. And after this, we'll move on. I don't think that we get too much more about airspace rights, but I could be mistaken. I know that we talk about it a little bit, but we don't go as deep into it like this for quite some time. Okay, so there is that. And that is our Cosby case. So let's take a look at Heinen's case, or Heineman, whatever it is. The appellant sues for damages and to enjoin the United Airlines and Pacific Air Transport, which would soon be merged to make United, from flying over their land allegedly at heights of less than 100 feet, but the appellants do not allege any specific form of injury from these overflights. Case dismissed because the plaintiff did not show any actual and substantial injury in this case. Okay, this is something that's important for basically any type of tort or property claim. You need to show an actual injury. You can't just complain that planes are flying over your land. You need to show why that injures you. There needs to be either like you're losing sleep, you own like chickens or your pets, and they're seriously disturbed by these low flights, stuff like that. You need to have that in order to bring a case. As part of a prima facie case, in most circumstances, you need to have actual injury. And prima facie cases are just cases where you've proven the prima facie elements. And I know that I'm defining it using the same term, but prima facie elements are just anything that you need to actually show to prove that you have a case. So you need to show that there's an injury in most circumstances. You need to show that the other person would be at fault, and you need to show that you can be compensated in some way. Those are the three basic things that most of the time you'll need to show in order to even bring a claim in a court of law. Okay, so here are some hypotheticals. We're not really going to bother with those. We're just focusing on the rules themselves, and we're going from there. Okay, now we're on to subsurface rights. And this is a big case that we talked about quite a bit. It relates to BP injecting down into the subsurface, like they're injecting down into sandstone and fracking. And the question is whether or not they're invading on someone else's property rights by injecting into the land beneath their own property and leaking over into somebody else's property. The appellants, which are the landowners next to BP, they claimed that they own everything below the surface of their property, and that since BP was injecting into the sandstone and it was leaking over towards the sandstone underneath their property, that BP was invading. The court dismissed that. We don't accept appellants' assertion of absolute ownership of everything below the surface of their properties. We therefore extend the reasoning of Willoughby Hills, whatever the fuck that case was, that absolute ownership of air rights is a doctrine which has no place in the modern world. Okay, that gives us our modern approach for air and subsurface rights to apply as well to ownership of subsurface rights. Okay. Given the unique facts here, we find that appellants' subsurface rights in their properties include the right to exclude invasions of the subsurface property that actually interfere with appellants' reasonable and foreseeable use of the subsurface. So, this is saying that you can only make a claim against somebody else if it's invading part of your subsurface that would actually interfere with your reasonable and foreseeable use of that subsurface. So this is very similar to the airspace laws that we have. You can only make a claim that somebody's invading your airspace if it's so frequent and low that it causes a disturbance and interferes with your use and enjoyment of the land. And below the land, you can only make a claim that somebody's invading the subsurface of your property if their actual interference is likely to interfere with your use and enjoyment of that subsurface property. So, we're going to take this. I apologize if I keep jumping back and forth between the outline and the PowerPoints too much. I really want to make sure that I have as much as I can in these outlines because, like I said, I can bring this into my final. So I want to get all of the actual rules copied over here, and I'm doing my studying now. I'm not going to copy and paste these later after I've explained everything. I'm going to explain it and copy and paste it as I go. So, and I'm going to bold that. Okay, I just got a text about something for this committee that I'm a part of. Oh, I don't think I've mentioned this on the channel yet, so I'll briefly mention it now and it'll come up later. Here, let me go full cam for a second here. But yeah, at ASU, we are going to be hosting a mock trade deadline competition in November, and that's going to be open to schools from all across the country. We're going to have schools come in and compete in an NBA mock trade deadline. You'll be assigned a particular team, and you'll basically be the GMs of that team, working with all the other schools to try and make deals on during the NBA trade deadline. We'll have a competition for it. We'll have judges come in who are actual NBA executives to judge what trades you make, what moves you make, and how it goes. We'll have some prizes, and currently I am on the executive board for that. My position is head of social media and marketing, which makes sense given what I'm doing right now. So I'll drop a link to our Instagram down below if anybody's interested in it, and I'll probably start posting more about that the closer that we get to it. But yeah, I just thought of it and realized I hadn't told any of you guys about the competition yet since I got that text. So with that, let's move back to reviewing property. God, I really do not want to be doing this today, but I have to. Okay. Okay, here are just some hypotheticals on it. Right to support. Okay, so this is something that we have that'll become important later on in certain cases. The right to support, which is you have the right to make sure that the land immediately beneath yours that supports your surface isn't infringed on. So to have land in its natural condition supported by adjacent parcel of land, Nora excavated on her lot to build a house on it. As a result, Owen's unimproved land subsided. Nora is liable to him even if the excavation was not performed in a negligent manner. So your neighbor can't dig up their property if it'll destroy yours. Like if your neighbor's property is supporting your property in some way, they can't just go and destroy it. So here is this rule, and we'll get rid of the bolding on that. Make that there. Italicize that. And okay, there we go. All right, and I think that's everything from. Oh no, there's a little bit more on this. So subjacent support to have land in its natural condition supported by the earth immediately below it. So someone can't go beneath your land and start digging up what's immediately beneath your land. So I'll copy and paste this over as well. Copy. And then I think this will be the end of air rights and stuff. Air and subsurface rights, I mean. Okay. And that should be the end of this PowerPoint. Here are the takeaways from this lesson. Personal property, we went over that. It's chattels, things like that. Adverse possession elements are the same for both personal property and real property. Common law rule for adverse possession provides that once the elements of adverse possession are met, the adverse possessor takes title, absent any concealment or fraud, which would violate the elements of openness and exclusivity and stuff like that. Modern rule, which is applied in most cases. Discovery rule provides that a cause of action begins when you have discovered or should have discovered. Okay, the original doctrine of what property rights we have has been modified in modern times. We no longer own property from our land all the way up to the heavens and all the way down to the center of the earth. Now it is prescribed by law. We just went over the flight stuff with the Cosby case, and then we have the subsurface rights that we see in the BP case, and all of those support rules. So that was class 6. Let's keep moving. Actually, you know what? I should take a look. How many of these do we have? There are quite a few. Oh my gosh, there are 25. And we are on 7. Oh my god. Okay. Well, luckily I don't have too much going on today. So, acquisition by capture. Okay, that's just a recap of what we've done. Okay, these are some other rules on how we can acquire property, and instead of being a real property like land, like we talked about with the Macintosh case, this is relating to acquisition of animals and stuff like that. This is one of the most important and famous cases in American law. In fact, it might be the most famous case ever in American law, and that is Pearson v. Post. In this case, an individual was hunting a fox. Here, I'll keep the picture up. That's probably more entertaining for you guys. In this case, one party was chasing a fox, hunting it for hours on end, and was just about to kill the fox and capture it. And then their neighbor, who didn't like them very much, swooped in, killed the fox right in front of them, took it for themselves. And of course, the guy that was chasing it and hunting it sued. And you would think that the guy that was hunting it for hours and had tired it out and was just about to capture it, you'd think that he would be the one to obtain title to the fox. But he didn't. The rule that we get is the person that fatally wounds it or removes its natural freedoms is the one who would possess it. So, the ruling in Pearson v. Post, a hunter pursuing or fatally wounding a wild, unowned animal retains no possessory interest, they don't own it, until it's actually killed or captured and subjected to the control of the pursuer. So, you don't own an animal that you're hunting until you actually subject it to your control. Okay, and this is one of the things that I mentioned before. In such a manner as to deprive them of their natural liberty and render escape impossible, that's a way that you can obtain possession. So, I'm going to copy and paste all of this, because this is one of the most important cases that we'll have. Is it titled by acquisition that we have this, or acquisition by capture? Okay. Pearson v. Post. It's funny, I actually met up with one of my old professors over winter break, and we were talking about law school and what I was studying and everything, and I mentioned tort law, and he asked if I'd read this case, which I hadn't yet, and he was baffled that I hadn't read this yet. And I, after hearing him explain it, I was also baffled why we didn't read it, but that's because it's most closely associated with property and not torts. So, yeah, I'm glad that I finally got around to reading it. In fact, I should probably let him know that it was in our property section and not tort section. I haven't reached out to him in a while, so maybe I will. Or who knows, maybe he'll watch this. I know that I sent him the link to the YouTube channel and everything back when I had like 1,000 subscribers or something. I'm not sure if he still watches or anything, but we'll see. Okay, back to the PowerPoint though. The minority has this weird view where you should have possession of the fox or of the wild animal if you're in pursuit and you have a reasonable prospect of capturing it, which doesn't really make sense. You could be chasing an animal and say that you have a reasonable prospect of capturing it when you're like hundreds of yards away and you just started following it. So when does pursuit begin? This is oftentimes too vague to be an actual standard that we apply in law. Part of the reason why the dissent went with this is because they were trying to change the way that the law was applied. The actual decision of this was based off of Old English common law. So, yeah. Now, as we are without any municipal regulations of our own, we are at liberty to adopt the learned conclusion that property in animals very naturally may be acquired without bodily touch, provided the pursuer be within reach or have a reasonable prospect, which certainly existed in this case, of taking what he has thus discovered an intention of converting to his own use. So they're basically arguing that now that this case was being decided shortly after the American Revolution, he's trying to say that now we can make our own rule. We don't need to follow the English common law, but we decided, this is actually an important theory in law in general, we decided to adopt a ton of English law and apply it to ourselves, and that's what we call the common law. Those are just old rules from England that we carried over and have built upon themselves over generations, and that's what we now know as the common law. It dates all the way back to Old English law, which in itself is originally based off of Old Roman and Greek law. So if you are a bit of a historian, you can actually trace some of our laws that we have today back to laws and legal theories from ancient Rome. And that's part of the reason why there are so many Latin phrases in American law today, is because that's just what it was called back in Rome, and it's just been called the same thing for simplicity ever since. There's a bit of a disagreement between the majority and the dissent. Minority wanted to use this as a form of social change, like I was just saying, and the majority wanted to follow the form that we already had. You see formalist opinions and views more often in stuff like constitutional law, which we will get to this weekend because that exam is on Tuesday. Shit. It feels weird having 4 finals, but yeah. Here's just some applications of it. Again, we're going to skip over this. There's also some background as to what theory of property supports this. that's not really as important. What's most important for law school and law school exams is to know what the rule is and what the law is and be able to apply it. If you understand the rationale, that's good. That's bonus stuff that you can do. But it's most important to first focus on this. And I personally don't have any issue with understanding the rationale behind any type of law that we get because I have a background in philosophy and studying this stuff. But if you guys are ever wondering what the justifications for certain laws are, let me know and I'd be happy to go back and explain it. Next up, we have a criminal case relating to this. I already covered Pearson v. Post and State v. Shaw the first review session because it was at the top of this. It was at the top of this outline here. So, and I realized that this outline is like somewhat useless to me because it's from a different class. So we're just we're refreshing this now. And also I want to like go over stuff the way that my professor had it because his way of interpreting the rules and the laws is different from how I would personally interpret some of the case law that we've read. So I want to study the way that he taught and then I'll restudy it for the bar whenever I get to that and study like how I believe it actually should be interpreted. Because there are quite a few of my classmates who are in a similar boat who think that we aren't really interpreting this the correct way, or he isn't, but oh well. So, State v. Shaw, as you can see by State, this is a criminal case, but it's relating to acquisition by capture, which is a property concept. In this case, there was a fishing company on the lakes on Lake Erie, and they had nets similar to this, where you can see there's like ways for the fish to kind of swim between the nets, and they can jump out of them if they really wanted to. And a group of individuals came and they started taking fish out of these nets. And when they were caught, they argued that it wasn't theft because these animals were still free since they could escape by like jumping over or by swimming through certain narrow gaps. Their rationale was even though they were in the nets of this company, they were free and wild animals because they had the possibility of escape. And the court said bullshit. They said they were so safely secured that the owners of the nets could have taken them out of the water at will as readily as the defendants did, so the owners of the fishing nets could have taken the fish whenever they wanted. The possession of the owners of the nets was so complete and certain that the defendants went to the nets and raised them with absolute assurance that they could get the fish that were in them. So these fish were in the nets. They were definitely in there. They had a possibility of escape, but for all intents and purposes, they were captured. We think, therefore, that the owners of the nets, having captured and confined the fish, had acquired such a property in them that the taking of them was larceny. So it was a criminal act to take them. So here are some questions on it. Was the trial just correct and direct and jury verdict of not guilty because the fish could possibly escape? Initially, the first judge said you should say not guilty if you believe that the fish had a possibility of escape, but the rule that they end up coming up with is no, these were captured. So here are some hypotheticals on it. Let me copy and paste this, and because this gives us like a stricter standard, and if he asks a question like based off of Shaw, so this will be useful. Okay. There is that. Okay. Now we are on to finder's law. So this can be fairly confusing. There are a ton of different categories of found property, and depending on what type of property it's classified as, that will determine what rule approaches and who has the rights to it. So and I think we have an entire other class on this as well. So let's go over this quickly, and then we'll copy this over to the outline and we'll explain some of the issues, and then we'll have cases. Okay, so there are four main types of found property. They are lost property, property which is lost when the owner property becomes lost when the owner unintentionally and involuntarily parts with it. So something falls out of your pocket and you keep walking not realizing that it's gone, that's lost property. Mislaid property. Property is mislaid when the owner voluntarily and knowingly places it somewhere, but then unintentionally forgets it. So have you ever left your phone, like you took your phone out of your pocket, you put it on a table at like the barber shop or at your friend's place, you intentionally put it there, but then you get up and you walk away and you like don't realize until you're around the corner that you don't have it with you. You unintentionally forgot it. That is mislaid property. You mislaid your phone. Or if you do the same thing with your wallet, you mislaid your wallet. Abandoned property. Property is abandoned when the owner knowingly relinquishes all right, title, and interest in it. So when you throw something away, that's abandoning it. When you like put something on the table and you're like, I don't want that anymore, anybody else can take it, that's abandoned property. And the last one, we don't see this super often, but it can create some interesting cases, as we'll see, I think, in the next PowerPoint, is treasure trove. Property is a treasure trove when the owner concealed it in a hidden location long ago, and typically this is reserved only for types of currency or extreme valuables like gold and silver. So let's create a new section of our outline for finder's law. And we will go over the different types of property. So copy. Anybody have any questions on those different types of property that I just mentioned? Okay, and let's just bold this, bold that. And this, for those of you who have been here for multiple of my review sessions, property probably feels like it's going way slower than stuff like criminal law. And that's because it is. There's a lot more that goes into property than there is with criminal law. Like criminal law was a 3 credit hour course, so we had it twice a week for an hour and a half, and property was a 4 credit hour course, so we had it twice a week for 2 hours each. So the amount of information in property law is a lot more than what's in criminal law. Okay. So our first case with this was Amory versus Delamere. In this case, a soldier was stationed at a particular house in, I believe, England, and while he was there, he was doing a sweep of a room, and he found on top of a windowsill a brooch. And it was a nice emerald brooch worth quite a bit of money. And the question was, what type of property was the brooch? And that would determine who had a right to own the property. So the question was it lost property, mislaid property, or abandoned property? And depending on the answer to that, the owner of it would either be the owner of the house where the soldier was stationed, the soldier himself, or the military, which was renting out the house. So, let's take a look at the deciding factors of this. So the finder of a jewel, though he does not by such finding acquire an absolute property or ownership, if you find something you don't automatically acquire full ownership of it, yet he has such a property as will enable him to keep it against all but the rightful owner. So if you find something, you have title to it against anybody except the actual rightful owner of it. So you find a wallet on the ground, you have right to it against anybody except the actual owner of it. The question in this case is, who is the true and rightful owner? We can boil this down into a finder has such a property as will enable him to keep it against all but a prior possessor. So the court ends up giving us this rule that the rightful owner would be a prior possessor of it. So since you don't know who like the actual original owner is, or the rightful owner, if a prior possessor comes and takes it, or if a prior possessor like acknowledges that they have a right to that piece of property, they can take it from the finder. But the finder has a property right against anybody except a prior possessor, so somebody that owned it before them. We're going to take this, put in our outline, and this Amory case is the first of like 4 cases that we have on finder's law, because it starts to get really confusing as you get further and further into it. So here we will Amory, and then this is the rule that we get out of it. Alright, and back to the PowerPoint. So okay, here are just some questions on why. Oh, Amory wasn't the one with the soldier in the house. Amory was one where a chimney sweep, while cleaning out a chimney, found a jewel, and nobody knew who the owner of it was. So the chimney sweep took it, brought it to a goldsmith to be cleaned up. The goldsmith tried to keep it, and the chimney sweep sued to get it back, saying that they were the one who should have the right to it. Goldsmith said, no, I should have the right to it, and the court decided that the finder has the right to it against anybody except the prior owner. So this means that the chimney sweep has it, or should be allowed to possess it, against anybody except the actual person that owned it before them. Okay, so in order to clear this up for my PowerPoint, or for my notes, this will be chimney sweep finds gem, goldsmith tries to take it. Chimney sweep has the rights against anybody but the prior owner. Okay. So if anybody has questions on that, let me know. But so here are some questions that might actually be useful. Typically we'll skip over questions relating to the problems that we did, but these are actually useful. So, did the chimney sweep own the jewel? No, they found it, but they didn't own it. They had a possessory interest or a right in it against anybody except the prior owner, but the chimney sweep couldn't be said to be the owner of it. Eventually, that would end up like voiding if nobody came forward, and the chimney sweep like sold it 30 years later. Then the purchaser of it could be said to like actually have ownership of it once a certain statute of limitations starts to run, because at a certain point, like we talked about before with adverse possession, the actual owner should have reasonably known that it was in the possession of somebody else. And in this case in particular, the court said that since the chimney sweep found it, they have the rights to it, but the goldsmith still refused to give it up. So the goldsmith was just forced to pay the value of it to the chimney sweep. And there's a question as to whether or not that makes the goldsmith the owner of it. And that's kind of up in the air. We don't really know like how that would turn out in a court of law. We have some ideas of how it might turn out, but those we'll get into with the next PowerPoint. So let's quickly go over the takeaways from these slides, and then we will move on to the next stuff. So you can acquire property by capture, like we saw in Pearson v. Post and back in McIntosh with acquiring actual property and land. A hunter pursuing or mortally wounding a wild animal retains no possessory interest. They don't have any right to possess that animal until it's actually killed or captured and subjected to the control of the owner or the control of the pursuer. The rule of capture applies to wild animals and on unowned lands and natural resources. If a wild animal is running across your property, then it gets a little bit fuzzier. One of my classmates had a question about that our professor didn't really answer, so we don't know how that would turn out, but this rule of capture typically is mainly applicable to public lands, like public hunting grounds. Rule of capture is limited by modern conservation laws. That's something that's true across all types of law. Like any rule that you have is likely to be limited or modified by certain state statutes or certain new rules that have come into effect. Where the capture happens says who has the better interest in it. Certain control of the property doesn't mean absolute control of it. So the initial hunter who was pursuing the fox in Pearson v. Post, he had certain control of the property, like it was within his grasp, but he didn't have absolute control. He didn't actually have it. Property rights are relative, so the pursuer would have rights to it as opposed to somebody who's on the other side of the world. And we see this in the finder's law stuff. The finder of the property has rights to it, but not against the prior possessor. The prior possessor has better rights than them, so they're relative to each other. Wild and unowned animals can be acquired by capture, like we mentioned. Acquisition requires either physical occupancy or mortal wounding while continuing pursuit or encompassing and securing such animals. Yeah, this is all of what we've been talking about so far. He basically copy and pasted the same things over a couple of times. Rule of capture may not apply to domesticated animals or animals that have the habit of returning. So, killing or capturing somebody's cow that's out grazing doesn't mean that you own it. Even if it wanders onto like public land, if it has the habit of returning and it's owned by somebody, then you killing it or capturing it and taking away its freedom doesn't mean that you immediately get the rights to it. The actual owner still probably has the rights to it, and you'd have to compensate them if you killed it. Shaw just gives a certain control, does not necessarily imply absolute control, and a finder has such property as will enable him to keep it against all but a prior possessor, which is the finder's law rule. Okay. Any questions on anything so far? I'm pretty sure that next we go more into finder's law, but that might be, yes, okay. we do go over some more stuff in Finder's Law. Here are the goals for this PowerPoint. We also go over gifts. Oh yeah, okay. Yeah, we go over different types of gifts and stuff, but let me just skip ahead. Okay, yes, there are a couple of important cases that we'll get through here, but first, before that, I am going to go and refill my coffee, and then I'm going to, let me pop that up for y'all. And then when I get back, we will get into that. So I'll mute myself and I'll be back in a few. Alright, I am back. We've been at it for about an hour and a half, so next up we are going to do some more on Finder's Law, and then after that, maybe take a break. I'm not sure how I'll be feeling, but we will get through quite a bit more today, because like I said, this final's on Friday, and I still have quite a lot to do, so depending on how you all are feeling, I may or may not pick up the pace as we're going through more Finder's Law stuff, but yeah. Oh, by the way, I am out of coffee creamer, so this is coffee with a little bit of half and half, and then just chocolate syrup in it, and when it's iced coffee, for whatever reason, the chocolate syrup doesn't want to mesh, like it doesn't want to dissolve into the coffee, so yeah, it all gathers at the bottom, so the top is just normal coffee and the bottom is chocolatey, so it's alright. I'm going to run and do some shopping hopefully tomorrow. I might do it after my interview, because my interview is actually right next to the Walmart that I go to, so but I want to make it back in time for the draft. Maybe I'll go shopping Friday after my final. We'll see. Okay, but that's enough about me. Y'all don't care about me. You care about law school. If you actually do care about me, then you can go watch my other videos or something instead. Okay, so we went over the law of finders, which says that you gain possession against anybody but a prior possessor. Like, you have the right to it against anybody but a prior possessor, and the rightful owner defeats the possession of anybody else. Okay. We already went over the different types of found chattels, and now we're going to start getting into some of the differences and issues that come up with trying to figure out what type of property it is. So, okay, this is a good background for who has what types of interest in it. So for abandoned property, the finder has the superior interest, and then wait, hang on. Intent of the owner determines the classification of the property. Courts looking at owner or possessor of the locus. Finder of the lost item may take possession of property, depends on private or public area of the property. Okay, so these are just some backgrounds and some rules on it. These will get fleshed out in the cases. And this is kind of an important rule. If the finder is an employee, then it's found for the principal. I'm actually going to copy that over to my outline, because that's saying that if you find property while you're working, then you're finding it for the employer. So if you find a wallet while you're working at a Walmart or something, you don't become the finder that has the possessory interest. Walmart does. And I know that kind of sucks, and you often see people not adhering to this. Like, I know when I was a bouncer, and if I found money on the floor, that's my money now. I'm not putting that in the pile to give to the owners. Like, albeit they saw me do that and they didn't care. Like, if there was a $20 bill on the ground, they're like, there you go. There's your bonus. All right, but this is the case that I was talking about before with the brooch. So, Peel is the rightful owner of the house. He bought the house from someone prior in 1938. In 1940, and it's important to understand that Peel never occupied the house. In 1940, the house was requisitioned by the government. For those of you who know your history, you know what was going on at this time. Hannah, an officer who was stationed at that house, finds a brooch on the ledge of a windowsill or whatever. A few months later, when he's off duty and can, like, has the chance to, he gives the brooch to the police. The police later give the brooch to Peel, the owner of the house, but the officer demands it and demands to get it from Peel, the owner of the house. But instead of giving it to Hannah, the owner of the house, Peel, sells it to somebody else, and Hannah files suit for damages. Okay. So, this is trying to decide whether or not Hannah, or whether or not Peel was the actual rightful owner of the brooch because it was found on his property. And here's the ruling that we're getting from it. So, a man does not necessarily possess a thing which is lying unattached on the surface of his land, even though the thing is not possessed by someone else. So this is saying that if you find something on your property, like if you find someone's ring or something on your property, that doesn't mean that it becomes your possession or your property, even if it's not being possessed by somebody else. The rule which governs things an occupier possesses as against those which he does not has never been very clearly formulated in our law. They're saying this is a fuzzy law. He may possess everything on the land from which he intends to exclude others, or he may possess those things of which he has a de facto control. So they're saying that if you can possess what's on your land if you intend to exclude others from using it, or if you have de facto control over it. So if you're actually in control of it. So I would have, like, de facto control over my textbook right here. I'm the one that's actually in control of it, even though it's not attached to my physical property. There is no doubt that in this case the brooch was lost in the ordinary meaning of the term. So that's the type of property that this is, lost property, not mislaid. And I should imagine it had been lost for a very considerable time. The defendant was never physically in possession of the premises at the time, so Peel was never in possession of the premises. It is clear that the brooch was never his in the ordinary acceptance of the term, in that he had the prior possession. So they're saying he never had prior possession of it and it's not his. He had no knowledge of it until it was brought to his notice by the officer. Okay, so in the end, the court ends up saying that Hannah should have been given the brooch and Peel has to pay damages. And some of their justifications for it are that it was lost property and Peel never knew of its existence, so he had no rights to it. Peel had no rights to it. But some of these policy justifications kind of cut the other way, like returning the lost item to the true owner. That means that it probably should have been in possession of Peel, because if the true owner went to go looking for it, where would they go look? The area where they likely lost it. And who's most likely to be at the house where they lost it? The owner of the house, not the soldier who was stationed there temporarily and is no longer there. Some of the policy justifications, carrying out the expectations of the parties. So what did Hannah expect to happen and what did Peel expect to happen? Well, they both expected that they would get the brooch, but Hannah expected that when they found it, it would go back to them, and that goes into rewarding honesty. So these can be seen to kind of like be split half and half. I think that the reason that the court mainly decided this is that it had been lost for a considerable amount of time, so you don't really want to bother looking at this first justification because the rightful owner would have already come looking for it if they wanted to. So Peel's main claim to having it, which would be I could more easily give it to the rightful owner, isn't really applicable. let me see what of this I want to. Okay, I am going to take this and the last sentence of that paragraph for the outline. And Hannah v. Peel there's that. And then we also have this. Okay. And these are the main things that we can take away from that case. And for those of you wondering, the only difference between like what I'm doing now and explaining this to you and what I'd be doing if I were studying on my own is I wouldn't stop to explain any of this stuff, and I wouldn't like take the time to think it through. I would just look for the rule, read it, and then copy and paste it over. So I'd be moving a lot faster, but I wouldn't actually be studying. That's the way that I used to study. I just would read it and then copy and paste it. So, yeah. Okay, so now we have bailments. Bailment is the transfer and delivery by an owner or prior possessor of possession of personal property to another, either for the purpose of safekeeping, repair, transportation, or for some limited purpose, and in anticipated return of the same and substantially in the same condition. So there are different types of bailments. These are kind of important to property law. They don't come up a ton with some of the like bigger issues, but this is just like when you give someone something or when you find something, you create a bailment, which means that the other party is trying to like hold on to it, keep it in the same condition for it to be returned later. The examples are like voluntary bailment, you leave your clothes at the cleaner, you expect them to come back to you in just as good a condition or better. There are different types of bailments. This is just going to be stuff that I'm going to like copy and paste over. Mutual bailments, both parties receive a benefit from the transaction, so you pay someone to look after something for you. And the bailee, so the person in possession of the property during this exchange, is expected to exercise reasonable care, and then unilateral benefit. So the bailee receives no benefit. Okay, so if this is just going over like who has the duty and what types of duties they have for different types of bailments. I'm not going to go too deep into it. It's just important to like have the note for it. If anybody has questions on bailments or whatever, you can type them in the chat and we'll actually go over it, but I don't think it's that important. Okay. Yeah, I'm going to start trying to go faster because there's a lot of stuff to get through. McAvoy v. Medina, this is the case that I talked about, like, I gave the example of leaving your wallet at a barber shop. This is that case. Let's see. The present case resembles Lawrence v. State, and okay, in this case they used like a couple of different cases to try and figure out which standard they should apply. And this just gives us what mislaid property basically is. And in this case, the person that should be in possession of the mislaid property is like the owner of the establishment. So the barbershop should hold on to the lost pocketbook because of the considerations that we talked about before, where the person that mislaid the property is likely to come back and look for it. So mislaid property should be held by whoever is in possession of the property where it was mislaid. And that's just giving us some policy justifications for why the barbershop should hold on to it, as opposed to the guy that sees that a wallet's left on the barbershop's table. Okay, this is an interesting case. In this case, they find money like sealed inside of an airplane, and they're questioning what type of property it is to see which party should be in possession of it. Okay, this is the most important rule that we can just get for finder's law. And this gives us everything that we need. So, I want this highlight the way that I want it to. Okay, there we go. I'll explain this as I copy it over to my outline. Common law rule of finders. Okay, so, damn it, I hate how it does this. Okay, so a finder of property acquires no rights in mislaid property. So if the property is determined to be mislaid, the finder doesn't acquire any rights in it unless a substantial period of time has passed and nobody comes to claim it. A finder is entitled to possession of lost property against anybody except for the true owner, and we define true owner as just prior possessor. So if the property is determined to be lost, the finder can possess it and has the right to it against anybody except for somebody that had it beforehand. And then a finder is entitled to keep abandoned property. They're allowed to just hold on to it, keep it. There's nothing, like, nobody can take it away from them. I'm skipping over, like, the actual outcome and the rule in, or the actual, like, outcome and decision in Benjamin v. Lindner, because there are, like, multiple parties. It gets very confusing, and the way that the court decided this is kind of bullshit and arbitrary. And if you look at the actual rule of law, it shouldn't have come out this way, but yeah. Now we're on to gifts. There are a couple of issues with saying that something's a gift. You need to, in order to actually give a gift to somebody and for it to be like legally binding that they take possession and have the possessory interest in it or the ownership interest in it, instead of you still retaining it, you need to meet 3 criteria. That's donative intent, so the person giving it must intend to transfer the property to the person receiving it. Acceptance, the person receiving it needs to actually accept it or want it. Typically, we presume that acceptance occurs if their item has any value, so this only really becomes an issue if somebody explicitly says, I do not accept this, I don't want to take it, blah blah blah. And then delivery. So the item must be delivered to the recipient. And these are inter vivos gifts. So I am going to make a new section here. Gifts. Inter vivos gifts. And we're just going to take this, copy it over. The main issue with gifts and the transfer of gifts is when delivery actually occurs, or if there has been delivery. And there's a very specific rule that we will get to. We probably won't go too deep into the cases because they aren't that important, as opposed to like understanding what the rule is. And there are a couple of different standards for when delivery has taken place, which we will get to when we talk about just the rule of delivery. So that's all copied over, and now we're back here. Okay, so all 3 of these things need to be met. Acceptance is very rarely an issue. Donative intent, that's also not that much of an issue. You can clearly see when somebody wants to make a gift. Delivery is the main issue. This oftentimes this is very important when people try to take things back, or when somebody dies. Oftentimes the estate or the living relatives will try and claim that stuff that was given to another party doesn't count as a gift because it wasn't properly delivered and should thus be given to them, the surviving party. And it gets kind of hazy, but it's also kind of funny to see. Like, there's this case that happened earlier, or actually last year, where Trayvon Diggs broke up with his girlfriend and demanded to get back a watch worth $150,000. The question is, like, was that a gift? And did he have the right to take it back? Because if it was a gift, she could have just kept it. If it wasn't a gift, then he could have taken it back. But she gave it back anyway, so that's neither here nor there. There are 3 ways that you can meet the delivery requirement for an inter vivos gift, and those are manual delivery, constructive delivery, or symbolic delivery. This is an order of how you would prefer to have it delivered. So manual delivery of an inter vivos gift means that you actually give the donee or the recipient the article in question, so what you're gifting them. Say I'm giving somebody a pen, manual delivery would be handing them the pen. Constructive delivery, which we only really want if manual delivery is impossible, is physical transfer of an object that gives them access to the gifted item. So you're giving somebody a house, you would give them the key to the house, which is the constructive delivery. It's something that allows them to access the property, and also you would give them the deed, which would be more symbolic delivery. So constructive delivery, you're giving somebody basically a key or like the passcode to go and like grab something. That's constructive delivery. Symbolic delivery, physical transfer to the donee of an object that symbolizes or represents the gifted item. So this is when you give somebody a deed. I'm going to take these and copy them over to the outline. For any of you that are planning on going to law school or in law school, outlining is very important and very beneficial, and I highly recommend that you do it during the course of the semester instead of doing what I'm doing right now, which is making it as you're studying for the final. Because if I already had this done, then I wouldn't have as much work to do. I could just focus on studying, but now I need to study and make the outlines. So I'm going to do this. And as you can see, like, this just slowly eats up the time that I have to study. Like, I still have multiple days for this, but if I didn't, this would be kind of a pain in the ass. The case that we have talking about delivery is ground versus ground, and this dad gifted his son a painting, and the question was the painting actually delivered? And in this case, they said that it was, even though the son never actually received it. They said that the gift was delivered because the son could have went to grab it at any time if he wanted to. He had a symbolic delivery of a letter telling him that he had right to the painting, and the opposing party mainly was saying that it wasn't delivered because the father kept the painting in his own house the entire time, but the court said that he had just reserved a life estate in that, and that was permissible. I'll go over life estates later when we get into estates and possessory interests a bit more, but for anybody interested, here is the letter that was sent, and these are the main questions. Donative intent, the question was, what did the father intend to give to the son? And the court said that based on that letter, he intended to give his son the gift of the painting while retaining a life estate for himself, so the right to have the painting until he died. Delivery, was the painting actually delivered? The court said yes, because there was the letter, and also the son had access to the house where it was if he wanted to go get it. Even though the painting was on the other side of the country, that's part of the reason why the court said that the letter was sufficient, because manual delivery of the painting was kind of unfeasible. So they said that the letter was sufficient, and then acceptance, like I mentioned before, acceptance is presumed if the gift has any value, plus there was evidence that the son, like, wanted the gift. He said thank you and stuff. Here's an important point on delivery. It's not necessary when the property is already in possession of the donee or the recipient. So say I loan you my textbook, and later I tell you, you know what, just keep it. I don't need to take the textbook back and re-deliver it to you. You're already in possession of it. These are just other little points. None of them are super important. My professor has some weird things talking about bank books and stuff. Nobody knew what a bank book was, because we all thought it would be like a checkbook, but it's something different. He said, just if you see that, you would an ATM card with a PIN written on it. So he asked us a hypothetical question about that on a practice quiz, and none of us got it. So that's burned into my memory, but okay. The other main type of gift that we talk about is gift causa mortis. These are gifts made in contemplation of death. without satisfying like an actual will, these conditions need to be met. Like, they're the same as a inter vivos gift plus imminent death. The donor must make the gift in anticipation of her imminent death from present illness. We have a case on this. Like, the husband is dying. I believe that he might have been suicidal, and he left his wife a note saying that he left all of the property to her, and the daughter was suing, saying that this isn't a valid gift. It should belong to me, the next of kin, as opposed to the girlfriend or significant other. And they ended up... Let's see. The estate fails to distinguish between the manner of a donor's death and the ultimate cause of the donor's death. And while the manner of the death may be suicide, that suicide may in some cases have been caused by a present mental illness, and that would qualify for in contemplation of death. Typically, suicide wouldn't like count as imminent contemplation or contemplation of imminent death, but if it's relating to a prior mental illness, then it can. So accordingly, even in a case in which the donor died by suicide, a party may be able to show that the donor made a gift in expectation of his or her death from a present mental illness, and that the present mental illness caused the donor's death. So in this case, they said that even though it was a suicide, it met the fourth requirement for a gift causa mortis, and I'm going to take this and put it in the outline as well. And that will be the end of what we have on gifts. So let me just do this. And put that this is required for a gift causa mortis. Okay. That is all that we have on gifts. At least I'm fairly certain. Here are the takeaways from it. You can find property. The duties will depend on or who has the possessory interest will depend on what type of property it is, whether it's found, mislaid, abandoned, and there are bailments, which the duties of the two parties will depend on whose benefit it's for, and we just went over the different rules and requirements for the two different types of gifts. That was class 8 out of 26. So let's keep moving. Let's see, what did we go over next? Okay, this isn't as important. This is when two people own something. It seems to be relatively straightforward. We have a couple of different types. This is where the course starts to get more in-depth and more confusing. This is another class that I missed, so these 3 categories I might take a little bit more time breaking them down, but there are 3 main types of concurrent ownership. You can have a tenancy in common, a joint tenancy, and a tenancy in the entirety. And this is where we'll start to get into conveyances as well. That's probably going to be the next PowerPoint if I had to guess. These are just how it can be conveyed. This is the important thing. This might be the only serious thing that we look at in this set of slides, but there are different requirements for each of these types of concurrent ownership. Then there's also questions on the right of survivorship and then severance, how you can separate that concurrent ownership and kind of get rid of it. So for tenancy in common, the traditional requirements are to transfer to two or more persons creates a tenancy in common unless the instrument shows different intention. That this is just how this comes into being. Joint tenancy, intent to create a joint tenancy shown in instrument and the four unities, blah, blah, blah. We'll get more into these as we go down the slides. You know what? This is something that we should refer back to later as we understand the rules more and more. Okay, so the reason why we study this is that each of these has different rules as to who has what rights to the property, and oftentimes it's ambiguous as to which type of concurrent tenancy or concurrent ownership is actually happening, and we want to sort that out and solve it so that way we know who should have which rights. The first case that we had, James v. Taylor, the question is tenancy in common versus joint tenancy. Okay, so I'm just going to skim through this and try and make heads or tails of it, and then once I've got what the case was about, we'll break it down. Nothing appears from corners of the deed in this case to indicate Mrs. Redmond's intent to convey survivorship interest, unless that intention is to be found in the term jointly and severally. Appellants do not cite, nor have we discovered through our own research, any Arkansas case in which a grant of ownership was made to two or more parties jointly and severally. As the Chancellor know below, jointly and severally are words of tort, not property. They have no meaning in the world of estates. Based on the foregoing, we hold that the deed in this case did not create a joint tenancy in the grantees. The language of the deed is sufficient to overcome the statutory presumption of a tenancy in common. Okay. Okay, and the reason why this was an important question is because the survivors of W.C. Sewell and Billy Sewell were suing to try and say that they possessed an interest in the property. But if it was determined to be a tenancy in common, then there's no right of survivorship. The children don't have a possessory interest. If it was a joint tenancy, then they would have a possessory interest. So the survivors of the two Sewells were suing, saying that they had part of an interest in property. Taylor, the defendant, was saying, no, you don't. This is a tenancy in common. And the court sided with Taylor, saying that there's not enough in the deed to show that the original conveyor wanted to create a joint tenancy, and that unless they want to look at the words jointly and severally, which the court said you shouldn't in this case. I'm just skimming through this to see what I should pull out. This doesn't have as many of the rules of law as the prior slides have been showing. Okay, this doesn't seem to be giving what I'd like to get from it, so I think that I might move on to the next PowerPoint and then come back and study this stuff on my own and go through the textbook for it. Okay, this I will copy and paste because it's an actual rule that we can get. I can't spell for shit today. Tendency in common, and then tendency in entirety. Then what are we looking at here? Co-tenant rights and duties. I know that this is boring watching me formatting this stuff, but it's got to be done. You know what a smart idea might be is to look at the other outline that I have access to and see if that can help explain some of what we're missing from these slides. Let me just skim through this slide a little bit more, see if there's anything important. Okay, this will come back to in just a second. Let me see if I can find anything here about different types of tenancy and who has it. A lot of this class is so much more in depth than what we did. Oh, they went straight into easements. Eminent domain. Their order was different from what we did. Yeah, these are the important types of estates that you can have in land. My question is why we went over like these different types of tenancies. Yeah, it doesn't even look like they went over this. Here it is, concurrent ownership all the way down at the bottom. Okay, so let's try and break this down from what this class had. So tenancy in common. O conveys to A and B. Can be held in differing percentages, can be taken at different times. Okay. Oh, okay. Hang on, I just got a text. Okay. Never mind, I'll handle that in a little bit, but okay. I'm just going to take this and copy it over to mine. Okay, let's drop that there. Actually, you know what? This is probably best to take their source formatting and just put it in here for that. Okay. Now that that's in there, and I'm also going to do the same thing for this stuff. Because if I remember correctly, what we have on marital property isn't nearly as in depth as this, so it'll be beneficial to just have this stuff here. Okay. Alright. A co-tenant in possession owes no rents to another even though the latter is not in possession. Okay. Okay, and here is where it's broken down. I don't know why he didn't break this down like beforehand. So there are three different types of tenancy: tenancy in common, joint tenancy, and tenancy in the entirety. Tenancy in common, each co-tenant has a separate fractional but undivided interest in the whole, and accordingly each tenant has a right to possession of the whole. This does or does not have survivorship. It does not have survivorship. Joint tenancy, on the other hand, does. Joint tenancy, all tenants must meet the four unities, which are in the other outline, and failure to do so severs the tenancy. Joint tenancy with the right of survivorship is not descendable or inheritable unless there is a severance. And the type of tenancy is determined from the four corners of the instrument. A co-tenant is not liable for contribution for improvement. General rule, the lease does not sever. Okay, this is confusing stuff that's not nearly as important as what we'll get into in a bit. So I think that was, what was that, 9? So here is 10. I'm guessing that this is going to go over some of the marital property stuff. Yep. Okay. There are different types of marital property. I already have this in the outline from copying and pasting it, but we'll skim through it. There's separate property belonging to one of the spouses but not the other. community property, property belonging to both spouses, and determining who owns what depends on like what state you're in and stuff. And tenancy by the entirety, a conveyance of a property to husband and wife. Okay, and that means that they both own the entire thing. So, the two main types of property, marital property systems are separate property and community property. Separate property is most common. Community property is rarer and only in like these states. During marriage, the separate property is the property is owned by whoever acquires it. For community property, equal shares in the property bought with income earned during the marriage. The property prior to it is still counted as separate. At least I'm fairly certain. At divorce, equitable distribution in separate property states, and then community property states, it's equal shares or equitable distribution. Separate property states at death, so when one of the party dies, it's elective share, however much the two of them have like decided would go to the surviving spouse and how much would go to the estate in general. Typically the whole thing just goes to the surviving spouse unless like there's a disagreement where that surviving spouse will leave the kids out of the will, blah blah blah. Community property states at death, the it's equally split between the estate and the surviving spouse. Okay. Okay, these are just some questions relating to it. Real quick, I am going to run to the bathroom, and I'll be back, and then we'll go deeper into this. Alright, I am back. It has been about 2.5 hours since we started. Uh, at this point, I'm going to start skipping over most of the cases that aren't super important and just trying to get as much of the rule of law as I can. I'm not sure how much longer I'm going to be at this. This is typically when I start to hit the wall during these studying streams, so I'm going to do it for a little bit longer, just basically copy and paste some rules. If anybody has questions, let me know, but I'll explain stuff that I can as I go, and then, we'll see if I end up doing something tomorrow. If anybody's interested in me, like, doing a live react or live stream to the NFL draft, let me know. That's probably what I'd do as a stream tomorrow. Tomorrow I'm probably going to study individually and not on stream. But for right now, let's try and get a little bit more work done now. Okay, so back to this. And okay. With that being said, we're going to kind of skip over this. This was just a case giving us, like, trying to decide who owned the property and whether or not they could be sued after their spouse's death for, like, their spouse's accident. The wife tried to take over, like, the husband's assets after the husband died, but because of certain rules, like, she couldn't be sued because she didn't actually own it, and you couldn't sue the children. So that's changed as of late, but this was just a not that important case. Okay. Okay, the rationale behind why they don't allow individuals to sue the surviving spouse a lot of the time is just because they wanted to choose the rule of law that would better support the family unit as opposed to the creditors of one of the spouses, so they ended up going with that rule. Oh, this was a funny case. In Guy versus Guy, they had gotten married while they were still in school, and the one spouse paid for the other spouse to go to school. And when they got divorced, the spouse that had paid was trying to say that the other person's degree, like, they should get half of it, but the court was like, no, we can't break that down. We can't decide, like, what half of a degree is. It's not a physical asset. We aren't going to give you half of their earnings in perpetuity either. That would be bullshit. So yeah, you get nothing out of that. There are prenups and stuff. We're just jumping straight to the takeaways for this. Separate property owned by one of the individual spouses. It's owned by the one that acquires it. Community property belongs to both. Tenancy by the entirety is created when it's conveyed to the husband and wife together. The division of property into separate or community, and it affects the distribution at death and divorce, basically. creditors cannot attach the tenancy by the entirety property to satisfy the debt of one of the spouses. So if one of the spouses is being sued, they can't attach the property that they both own as tenancy by the entirety to it. You know what? At this point, my brain is starting to just shut down. It doesn't want to study right now. I know I still have quite a while to go, but I don't think you guys just want to sit here and watch me stream doing nothing and relaxing in between the lessons. So I think I might actually just cut it here and then go back and do some individual studying later. I hope you all enjoyed the stream. Like I said, I'm not sure if I'm going to do anything tomorrow. Probably not a studying stream. I have to prepare for that interview, and then there's that, and I also want to do some studying individually, so I don't think I'd do a studying stream tomorrow, but if anybody is interested in watching me do a reaction to the NFL draft or anything along those lines, feel free to let me know. I'd be open to the idea of it. I'm not entirely sure how it would work, but then again, I wasn't sure how this would work until I started doing it, so yeah.